Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm. And I'm your host, Alan Kaplinski, the former practice group leader for 25 years, and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'm very pleased to be moderating today's program. For those of you who want even more information, either about the topic that we're going to be talking about today or anything else in the world of consumer financial services, please don't forget about our blog, consumerfinancemonitor.com. We've hosted our blog since 2011 when the CFPB became operational. There's a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. You can leave us a review on Apple Podcasts, YouTube, Spotify, or wherever you access your podcasts. And also, please let us know if you have ideas for any other topic that we should consider covering on a future podcast show or speakers that we should consider as guests on our show. Today's episode is the first part of a two-part series based on a webinar we recorded on November 4th that was entitled The CFPB's Most Ambitious Regulatory Agenda Ever. We will be releasing the next part of this webinar, repurposed webinar, next Wednesday, December 24th, rather than December 25th, because of the holiday. Okay, so today we're going to be primarily discussing the CFPB's spring semi-annual regulatory agenda. And this one is particularly noteworthy. It's the first regulatory agenda released under the Trump administration, and it's unlike anything we've ever seen before. For starters, it includes 24 separate rulemaking items, the largest number ever published in a CFPB agenda. On its face, that's an incredibly ambitious plan, maybe even overly ambitious, especially given that the Bureau's rule writing staff is expected to shrink to just 10 lawyers following an anticipated reduction in force, assuming that the CFPB continues to prevail in the litigation initiated earlier this year by the various labor unions and others representing CFPB employees. It's also absolutely impossible to reconcile this agenda with Acting Director Russell Vought's recent statement that he'll be shutting down the CFPB in 2 to 3 months, coupled with the fact that, as recently reported by the media, the CFPB is running out of funds by virtue of the fact that Acting Director Vought has so far refused to request any funds from the Federal Reserve Board to perform even statutorily required functions, or, for purposes of our subject matter today, to complete the deregulatory functions on the CFPB regulatory agenda, which the industry strongly supports. So we've got a lot to unpack here, and I'm going to very quickly introduce our speakers for today. And leading off will be Rich Andriano, a partner and the practice group leader of our mortgage banking group, John Colhane, a partner in our consumer financial services group, Greg Sefcik, a partner and practice group leader of our privacy and data security group. Of counsel, Kristen Larson and Rob Lieber. And associates, Aja Finger and Mofam Khan and Dan Wilkinson. They are going to walk you one by one through the highlights of this agenda. We're actually going to cover all 24 items and one additional item of importance that was not on the agenda. So without further ado, let me turn the program over to Rich, and we're going to take it from there. Go ahead, Rich.
Thank you very much, Alan, and good day, everyone. We're going to start out with items in the final rule stage, and here they are. There are final rule stage items, proposed rule stage items, and then also long-term actions. We will address all of these, starting out with a mortgage servicing proposal. This came out last July 10th. In fact, the Bureau released the rule on its website and then published in the Federal Register. Now, it characterized the proposal as one that would streamline mortgage servicing for borrowers experiencing payment difficulties. And indeed, the industry does, in fact, want amendments of these rules. They view them as being overly burdensome. And what the Bureau did, however, was something that would impose significant operational and cost burdens on servicers. It would certainly increase borrower protections, but it wouldn't require that borrowers actually participate in the loss mitigation process, and that's a significant issue. To give you an idea how expansive and burdensome this would be, during a loss review mitigation cycle, and that would basically be the period from when the borrower requested assistance until there was some resolution one way or the other. Notwithstanding the fact that the loan documents would allow the servicer to impose various fees on the borrower in delinquency, the rule would prohibit that. It would only permit fees as if the borrower had made all contractual payments. So it wouldn't permit various delinquency fees, such as sending out someone to assess the property's condition, and that. Wherever they think they have the authority to do that, I find questionable. Now, as you might expect, industry trade groups, including the Consumer Bankers Association and Mortgage Bankers Association, joined in a comment indicating that they did want streamlining of the loss mitigation process, but not in the way that the Bureau had proposed. And they indeed want regulatory changes that would require the borrower to actively participate in the loss mitigation process. Another big factor, and this has been an issue with the Bureau going back to its formation, is the lack of care of cost-benefit analysis. And this rule would impose significant costs without really a significant assessment of the benefits and whether those benefits to the borrowers were worthy of the cost to servicers. Also, interestingly, the Bureau, I put proposed in quotes, limited English proficiency measures. There wasn't actual language in the proposed rule text of those measures. The Bureau just discussed concepts in the preamble to the proposal, and for some reason it believed it could do that and go to a final rule, which I find extraordinary. And that was criticized, and even some consumer groups had some issues with the proposals, believing that if implemented, it actually could limit marketing other than English, which actually would not be a very good thing in general for consumers. Now, I'm surprised they say they're moving forward with this rule because, as we will get to shortly, they're also proposing to address the discretionary aspects of the servicing rules under the Real Estate Settlement Procedures Act and Truth in Lending Act. And I'm also surprised, given this administration's opposition to imposing burdens on the industry, given the significant industry opposition to this based on those very burdens. Now, if the final rule looks anything like the proposed rule, there will be litigation, and I think that litigation will, in fact, be successful because I find a lack of authority for many of the things that are in the proposal. Now, the regulatory agenda targets December 2025 for action on the final rule. As we will see in the presentation today, many of the target dates in the regulatory agenda have passed without any issuances occurring. Also, given the fact that most of the Bureau is standing down and it's running out of funds, I find the December 2025 date to be somewhat unrealistic. But we will have to see what happens. With that now, let's turn to another proposal addressing financial data transparency, and I turn it over to Mo and Greg.
As Alan mentioned, and as Rich mentioned, I'm joined by Greg Sevchek, who is the chair of Ballard's Privacy and Security Department. And today I'll give a quick practical overview of the Financial Data Transparency Act and the rulemaking developments there. Greg is going to give an overview of the reconsideration of the CFPB's financial personal rights rule later in the session. So what is the Financial Data Transparency Act? It is a law passed in 2022 that asks financial regulators to adopt uniform, interoperable data standards for supervisory reporting so that the data that these agencies are collecting becomes searchable, comparable, and reusable across the government. So who is covered? These are going to be member agencies of the Financial Stability Oversight Committee. A list of those agencies, to give you kind of a feel of what those regulatory agencies are organizations like the Federal Reserve, the CFPB, the SEC, the FDIC. These are federal financial regulators. And the idea, as mentioned, is to adopt uniform standards between these organizations that are collecting all of this financial data so that it can be used across intra-agencies. So the question then is, what are the standards going to look like? The standards are supposed to be open, non-proprietary, machine-readable, technology-neutral. The proposed rules that have been submitted discuss use of legal entity identifiers, or LEIs, and other identifiers to improve interoperability. And the way this is going to ultimately have downstream impacts on businesses is as agencies adopt these joint standards, entities are also going to create their own standards based on the joint standards and will likely flow down these standards into form submissions that businesses do to these entities. And so that's the practical impact that we're going to see. But that brings me to the next slide of where we are currently and kind of what the timeline is. So the FDTA was enacted in 2022. We had joint standards proposed for notice and comment in October 2024 is when the notice and comment period ended. And so right now where we are is waiting for joint rules to be adopted as final. And after that period, there will be a 2-year period in which agencies will then adopt their own specific standards, incorporating the principles of the joint rules. So at a high level, what's in the proposal currently? It's very principle-based. So it's not specific standards, but instead favoring that entities adopt standards that are interoperable, machine-readable, and are practical. So really what we're going to see with specific developments is when the agencies adopt their own specific rules, which will happen after the joint rules are finalized. So what we can expect likely is going to be a phased rollout. One of the items mentioned in the joint standards that have been proposed is emphasis on minimizing burden for smaller filers in particular. And what the overall goal is going to be is just making data that's already being provided more usable across agencies. And so I think that's one of the most important things to keep in mind from a business perspective is this isn't changing the data or requirements of the data that needs to be filed based with these different regulatory agencies. The goal is instead to make the data uploaded in a form that can be used across the agencies. So in a nutshell, that's kind of where we are with the FDTA. It's kind of a wait and see situation. Once the joint rules are finalized, we'll then see the agencies provide more detailed and specific guidance is what we're expecting. And so I would expect we'll see movement within a year or two on this, particularly because the 2-year period for the agencies to adopt their specific standards is triggered once the joint rules are adopted. So moving on to the next portion, I will turn it over to Kristen, who will talk about the remittance transfers.
Yeah, so the CFPB proposed this rule, and this is more of a technical type correction under Section 919 of the EFTA. remittance transfer providers are required to include on the receipt a contact information for the state agency that's regulating the remittance transfer provider and the CFPB. And what the problem was is it was directing people to contact the CFPB for all these questions or complaints, and the CFPB obviously is not in the right place to be able to help people. They have to refer them back to the provider. And so essentially they're working on changing the language to change it to, well, if you have unresolved problems with the remittance transfer provider, then you can reach out to us. And so it's a lot of it is just work to kind of clean up. And I show on these next slides how they're proposing to revise the model form. A lot of these changes just make sense and will add more value to the customer experience. And with that, I'm going to turn it back to Rich.
Now, this is more of a housekeeping matter here. The rescission of the protections for borrowers under the COVID-19 emergency rules. The reason why I say it's housekeeping, because under an interim file rule, these already have been rescinded, but actually by their own terms, a number of their provisions had already expired. And so this is really cleanup. Now, why were the rules there in the first place? As we mentioned before, the servicing rules with loss mitigation are burdensome. They actually hamper the ability of servicers to move quickly to implement loss mitigation measures for consumers. During COVID, given the significant number of consumers who were affecting financial difficulty, those rules provided a barrier, or were a barrier to quick forbearance and other loss mitigation implementation. As a result, what the Bureau did is adopted temporary rules, one, to add some additional protections so far as preventing the servicer from moving for foreclosure unless they had passed a certain additional hurdles, but also simplifying the method to implement streamlined loss mitigation. That proved to be very helpful. That provision, as you will see in that bullet point, actually expired of its own accord back in January of 2022. As to the safeguards, the streamlined modifications continued, but those have now been rescinded under the interim rule. There were some additional live contact requirements. The thought was get to the people quickly to see if we can, the quicker you get to them and talk with them, see what they need, see what assistance they might require, how long they might be facing difficulty. Those also expired back in October 2022. Interestingly, most small servicers were exempt from these. Now, the interim final rule had the comment deadline and then an effective date, so it is effective today. Oddly, the regulatory agenda had no target date for the final rule, but that's really more a housekeeping matter because these rules are rescinded under the interim final rule, and I don't expect much opposition to the finalization of that interim final rule, given that the measures at this point are not needed. And what will happen is there will be additional rulemaking things going forward. Now, with that, I turn the presentation over to John Culhane.
Thanks, Rich. I'm going to take us through developments with three rules that are procedural in nature, but very important for the industry. And I'm going to start with the changes to the procedures for designating an institution as posing risk. There's a really significant development here. Recall that the dormant authority of pose risk supervision was invoked with great fanfare by Rohit Chopra back in April of 2022. And the rules that he set in place, unfortunately, put industry members in an extremely difficult position because it basically created a Hobson's choice in these supervisory designation proceedings. An entity would receive a notice of reasonable cause from the Bureau, and if the entity challenged it and contested it and lost or won, the CFPB would make its determination public, basically adopting a name and shame approach. And no contestants have ever won in any of these CFPB proceedings. On the other hand, if you consented, the CFPB would then treat everything going forward as confidential supervisory information. World Acceptance back in 2024 found out the hard way that contesting these proceedings was not an optimal choice. The CFPB proposed to make this change back in May. It only got 8 comment letters, and not surprisingly, the industry supported it. Consumer groups did not. The final rule was published on September 25 in the Federal Register, took effect on October 27, and it eliminates the publication of determinations. It also made some other changes to the processes that the CFPB follows, and I've listed them here, and you can look at them at your convenience. Let me move from posing risk to the rescission of rules of practice for adjudication proceedings. These are the rules that sort of the CFPB's counterpart to the federal rules of civil procedure or state rules of procedure. These are the rules for determining how adjudication with the CFPB works. The final rule was just recently published, and it rescinds a lot of amendments to the rules that were made back in February of 2022 and March of 2023. Probably the most significant one was the amendment that basically gave the director the ability to decide all dispositive motions. So that's a very atypical structure of the normal practice in an administrative proceeding. Is the hearing officer makes that decision, you proceed, and then you get to the end, and there's an appeal to the agency head. So that's going to be gone. Other changes that were made by these procedural rules were largely viewed as being unnecessary. And I want to comment on just a couple of them. There's a fairly exhaustive list here. There were changes about expanding opportunities for depositions. The more significant ones, I think, from the industry standpoint, were the ones involving the content of answers, the bifurcation of proceedings, and the requirements for issue exhaustion. So the CFPB had adopted a rule that required that in any administrative hearing, the industry member that was defending the action articulate all of its basis for defending against the action. So not just affirmative defenses, but any legal theory for avoidance. That tracked changes that had been made at the time to the SEC rules, but it obviously put a big burden on industry members, and not surprisingly at the time, industry members objected to that. The bifurcation of proceedings was somewhat like the procedures for deciding dispositive motions. That authorized the director to decide how the hearing would take place. And again, that was challenged as inappropriate and something that was really should be done by the hearing officer. Issue exhaustion was another change that was pretty significant in that it required the parties to exhaust all issues, both raise all issues before the hearing officer and exhaust all issues in that proceeding, and then raise them again before appealing to the director. This requirement had been criticized for reducing access to courts or discouraging access to courts and requiring industry entities to articulate separation of powers and constitutional claims before the director, and the director had shown an unwillingness to accept any of those arguments. Is the withdrawal of the rescission, so the withdrawal of a final rule, rescinding the rules for requiring state officials to notify the CFPB before bringing actions. The CFPB had published a final rule withdrawing this notification requirement, or the rules setting forth the notification requirement, arguing that basically they simply tracked the statute. The statute was pretty clear on its face and wasn't really necessary to have formal rules for notification. We often see changes of this sort when there's a change in administrations and an agency is trying to reduce its number of rules. It will eliminate ones that it concludes largely track statutory requirements. When the CFPB announced that it was going to rescind these rules, it said that it would withdraw the rescission, that is, reinstate the rules, if it received significant adverse comments by the comment deadline. And it received a number of comments, and apparently these are the ones that considered it to be significantly adverse, or at least to raise significant issues. Two organizations argued that the rescission really exceeded the CFPB's statutory authority, in effect arguing that the CFPB really was required by Dodd-Frank to adopt rules here. And so it couldn't just rescind them because that would leave the notification requirement in a bit of a limbo. Likewise, another responder argued that it was arbitrary and capricious, and then argued that the procedural posture for withdrawing the notification requirement was improper. And still another organization really twisted this back to some issues that had been decided adversely in the courts, arguing that the CFPB should require a much earlier notice, not the notice that it currently requires, and then conduct a very rigorous analysis of the proposed action, apparently suggesting that the CFPB might then lobby any state to try to dissuade it from moving forward with the action. So the final rule was withdrawn. The CFPB has said it intends to address these comments that it received in a subsequent rulemaking, query whether that will happen for the reasons we've been discussing. No people and no money. Where we are now is that the June 2012 rule is back in place, and states have to give the CFPB at least 10 days prior notice before initiating a Consumer Financial Protection Act claim, although that is somewhat of a perfunctory requirement. Let me stop here and let me turn it over to Dan to talk about the non-bank orders registry.
Thanks, John. So the CFPB published a final rule rescinding the rule that was made back in 2024 titled Registry of Non-Bank Covered Persons Subject to Certain Agency and Court Orders. And so this original rule established at the CFPB was to maintain a registry that collects information about publicly available agency and court orders for these. The rule also required these covered persons to register with the CFPB and to annually identify the executives responsible for the firm's efforts to comply with all of the orders that are identified in the registry. And so effective October 29th of this year, the CFPB rescinded this rule, and the CFPB really stated in this rescission the high cost to do this and the low benefits to consumers. So the high costs are, one, the CFPB estimated it would cost $2.5 million just to establish and maintain this registry, and it would also take over 10,000 worker hours. So talk about saving money and saving worker hours. Maybe this is how they come to making all of these other rules. And then also the CFPB determined it was unnecessary. And so the original promulgation of the 2024 rule, the CFPB even stated they did not expect a wide group of consumers to routinely rely on this online registry when making decisions about choosing consumer financial products and services. So because of these two things, the CFPB rescinded this rule, and now going forward, the CFPB believes that this may cause more financial products and better financial products in the market. And with that, I'm going to turn it back to John.
Thanks, Dan. I'm going to talk about one item that we added here, although it wasn't really in the regulatory agenda, and that's the interpretive rule that the CFPB just issued regarding the extent to which the Fair Credit Reporting Act preempts state laws. So you may recall that in July of 2022, the former CFPB issued an interpretive rule concluding that the preemption under the Fair Credit Reporting Act was not as broad as I think industry members expected. In fact, was extremely narrow and limited to the very specific items listed in, I think it's Section 625 of the Fair Credit Reporting Act, not the broader subject matters, subject areas addressed by those the provisions. And the CFPB withdrew that rule in May of 2025, but I think it concluded here that it was important to get the arguments on the other side out in the public domain in a more significant way. So what it did here was issue an interpretive rule taking a broad view of Fair Credit Reporting Act preemption, even though that interpretive rule might not get any deference based on the Supreme Court cases that we've talked about in other webinars. But I think the CFPB concluded it was important to get this argument out in the public domain in a very significant way and a very public way. And so that's what it did. The CFPB reviewed the statutory text and the legislative history and reached the conclusion that the preemption under the Fair Credit Reporting Act is actually very broad, very strong preemption, and that Congress's intent here is to create national standards for the credit reporting system. It's not to open the doors for states to regulate the reporting of medical debt or cosigner liability on auto loans or on student loans or any of the other topics that states have sought to restrict on credit reporting. So let me stop here, and I think who am I turning it over to? Oh, next one's me. Sorry about that. Okay, we're going to go to proposed rules. Let's go to the high-cost installment loans rule. Basically, the news here is that there is no news. The payment restrictions under the high-cost loan rule went into effect on March 30. These are the requirements that preclude a lender from making a second attempt to withdraw a payment or basically deem it an unfair and abusive practice to attempt to withdraw a payment after there's been a second consecutive failure due to insufficient funds. I think everybody remembers that this rule had a very tortured history. It was very broad when originally promulgated in 2017. It included significant ability to repay requirements as well as limits on successive loans. Those provisions were rescinded under Kraninger, just leaving the payment provisions in place. They were challenged in litigation, and then they took effect. And the CFPB had previously announced that should be on March 28, not March 25, on March 28 that it would not prioritize enforcement and that it would revisit the rule. It has not revisited the rule to date. Just a reminder that the rule as it exists, even if it's not going to be enforced by the CFPB, can still be enforced by state attorneys general and state regulators under Section 1042A of Dodd-Frank.
Thanks, John. So, we're going to talk quickly about the Personal Financial Data Rights Rule, or also known as the Open Banking Rule, or 1033, which, it was another long, tortured rule process that stretched back to 2016, with the final rule being entered last year in October of 2024. We've done 20-minute webinars on the final rule that barely scratched the surface, and we've spent dozens of hours working with clients on compliance. So, we can't really go over much with the rule, but at the highest level, the rule would have required covered persons to make consumers' financial data available upon request, both to consumers and to third parties in a secure and reliable manner. And it would have required the build out of new portals for the transfer of this type of information. The final rule didn't apply to all financial institutions. It only applied to institutions under Reg E, card issuers under Reg Z, and other persons that control or process information concerning covered financial products or services obtained from that person. So we're talking about entities like banks, credit unions, and other providers of checking, savings, and credit card accounts, and various other payment accounts and products, and especially, with a focus on things like digital wallets. The final rule defined third parties to mean any person or entity that is not the consumer about whom the covered data pertains, or the data provider that controls or possesses the consumer's covered data. So a third party could be another financial institution that could be a data provider in its own right, but it also could include FinTechs and data aggregators. And the final rule had some special rules for data aggregators, which would be defined as an entity that is retained by and provides services to the authorized third party to enable access to covered entities. So, that rule was supposed to, was passed as a final rule in October of 2024. There was litigation that put some temporary injunctions in place at the beginning of this year. And then in August of 2025, the CFPB flagged for reconsideration the rule, requesting additional feedback with an ANPR. In that ANPR, the CFPB listed 34 questions on which it was seeking comments under 4 major headings. And those headings are, can be consolidated down into, who is a representative of the consumer, who can be an authorized third party, who can request that consumer's financial data. Another is how to allocate the costs of providing data at the consumer's request. One of the big issues that we saw with the final rule was a concern over, where the costs came from. The costs were ultimately borne by the covered persons, which were usually banks. And we saw a lot of pushback on that front. We saw that in the litigation. We saw it in the comments on the first part. What these requests in this ANPR are getting at are, how is that supposed to be allocated between the consumers, between the third parties, and between the covered persons, especially as some of the costs related to developing the new portals is mostly going to be borne by those covered persons. Circling back to the, who can be a representative of the consumer, some of these ask whether it should be limited to just a fiduciary. If it goes in that direction, it would significantly limit the scope of this rule. Others get down to how does the rule account for the information security threat environment? Under the final rule for the third parties, many of which would be FinTechs who are not subject to some of the banking rules, it will push down the GLBA's safeguard risks. But the rule is largely silent as to who will ultimately bear responsibility for security incidents that may occur and other data privacy risks. So, what the CFPB is asking in the ANPR is, how do you allocate these risks related to the information security threat? It's necessarily going to be coming into play here when we're talking about the transfer of sensitive personal data. And on that fourth point of how to ensure consumers understand what they're authorizing so they have a say in their data privacy, when there's an authorization to a third party, we are talking about, and especially if it's going to be beyond the confines of a fiduciary, it's going to be the authorization of sensitive personal data to third parties who may have additional rights that the consumers might not always be aware of, depending on how the authorization is structured. And so, when we're looking at the 34 different questions and that can be classified under these 4 major headings, it's clear that to the extent that the CFPB is going to revive the rule at all, it's going to be narrowing 1033 across the board. The ANPR closed October 21st. But it's important to note that although the comment period is over now, the effective dates for the original final rule, which would have kicked into effect in April of 2026, have been enjoined by a preliminary injunction in the Eastern District of Kentucky in some litigation that had been going on there. And that preliminary injunction has enjoined them for the entirety of this proposed rulemaking process. And so, although we don't have the timeline for when the CFPB will be acting on this proposed rulemaking, now that the comment period is closed, the original final rule is stayed until there is any action on this. And so we are in a stay tuned situation when it comes to 1033. And with that, I'll turn it back over to Rich.
Thank you very much. Let's move on to the Small Business Data Collection Rule under the Equal Credit Opportunity Act, which is in the proposed rule stage. And some might then say, but we have a final rule. Why is this in the proposed rule stage? Well, this beleaguered rule. Let's review the history of what brought us to today and why it's listed in the regulatory agenda under the proposed rule stage. In fact, a final rule came out over 2 years ago, May of 2023, provided for an effective date of that August 2023 in tiered compliance dates, which, as we will get to, have been pushed out a number of times. Now, Congress in Dodd-Frank, and this is a Dodd-Frank rule, required the Bureau to adopt a rule requiring small business lenders to collect data on small business loans, somewhat similar to data collected in the Home Mortgage Disclosure Act, and to report that to the government, similarly what is done under the Home Mortgage Disclosure Act for residential mortgage loans. Now, Congress, added, as it did with some HMDA amendments some years ago, it specified certain data points that had to be in the final rule, but importantly, it gave the Bureau authority to add additional points. And boy, did they add additional points. They added a significant number of additional points, including adding an ownership category. One of the main categories that Congress specified was to indicate whether this small business was minority or woman-owned. Based on comments that the Bureau received on the proposed rule, it added as an ownership status LGBTQI+, as a lot of small business owners who are in that category indicated they believed they had, in fact, faced discrimination because of their status. Now, right after the rule was released, it immediately faced opposition in Congress in both the House and the Senate. And reading a lot of comments of members of Congress, it became clear to me that they had no clue that the Bureau was required to adopt this rule under Dodd-Frank, and that, in fact, the Bureau was facing a lawsuit to implement the rule since it had taken so long to start the rulemaking process, and was forced to, had agreed to, in fact, issue the rule when it did in 2023. House and Senate voted to rescind the rule under the Congressional Review Act. However, President Biden vetoed that, and the Senate was unable to override, so the House didn't bother, given that the Senate could not. Rule is also facing 3 lawsuits, and all of those lawsuits have stayed the rule for the plaintiffs, interveners, and their members, which will explain CFPB action that I'll reach shortly. Importantly, one is the Fifth Circuit, so we're at a circuit court appeal, and the other 2 are district courts. Now, more recently, some of the original plaintiffs that sued to force the Bureau to implement the rule have now sued again, rather to adopt the rule, have now sued seeking the Bureau to implement the rule. How that's going to turn out in the D.C. District Court, given we have a Fifth Circuit stay and a stay by district courts in Florida and Kentucky, remains to be seen. Plus, there's additional development we'll get to on the next slide, which may cause the court perhaps to pause. Now, the Bureau in October 25 again pushed out the compliance dates depending on the volume of lending. It's 3 tiers, and we'll get to those shortly. The soonest compliant dates for the largest small business lenders is now July 1 of next year. That will almost certainly be pushed out pending whatever, caveats subject to the court cases and what may happen because of them. And we'll get to why would that be pushed out. Now, first, here we have another prompt for those of you seeking CLE credit. Please enter the information or indicate you're still listening so you can get your credit. Now, tiers 1, 2, and 3. Largest lenders originated at least 2,500 covered loans in 22 and 23. Both, you had to do it in both years. Tier 2, at least 500 in 2022 and 2023, but you're not a Tier 1 lender. And the last category, at least 100 covered loans in 2024 and 2025. That's because their compliance date was later, and you're not in Tiers 1 or 2. Now, the October rule allows lenders to use the original 2022 or 2023 loan volume, but they have the option, and this would be really for Tier 1 and Tier 2 lenders, of using 2023 or 2024 or 2024 or 2025. That would give some lenders the ability, perhaps, to curtail their small business lending to either drop out of a category or drop into a lower category with a later compliance date. Now, why do I think that July 1, 2026 compliance date may be pushed out? The Bureau has said it now plans to issue a proposed rule to reconsider certain aspects of the final rule. They targeted October 2025 for a notice of proposed rulemaking. As indicated before, they have not met many of the dates in there, and given that there are very few people at the Bureau working and it is running out of funds, who knows when we will see a proposal. However, what I suspect when we finally do see a proposal, I think the proposal will align the rule much closer to the statute. In other words, they'll cut out a lot of the discretionary categories that the Bureau added under authority granted by Congress, and that the rule will look much more like what is in the statute. The one caveat to all of that is, what if there is congressional action to amend the statutory provision? That may be unlikely because while the House could easily pass legislation, in the Senate that would require 60 votes, meaning at least a number of Democrats would have to join with the Republicans to revise or repeal that requirement, and that's probably unlikely. So I think at some point we will see a small business data collection and reporting rule, and that rule will probably look a lot more like what is in the statute as opposed to what the Bureau adopted originally.
Please be sure to join us next Wednesday, December 24th, for the second part of this repurposed webinar. Some of our panelists in part 1 will return including Rich Andriano, John Culhane, Kristen Larson, and Daniel Wilkerson. And we'll also be joined by two members of our Consumer Financial Services Group who were not involved in part one of the repurposed webinar, namely Aja Finger and Robert Lieber. Thank you for listening and have a great day.